The phones were not kept safe, number one. They were tampered with, number two. Agent Karate said that he tried to access the phone. He was caught in the act by the third eye intruder. It may be that he was only trying to put it in airplane mode, but the point of the matter is, without a warrant, they tried to enter Mr. Ibarra's phone. That is exactly what our case law prohibits them doing.
We're focused on the murder of Laken Riley, the University of Georgia nursing student killed while she was out on a jog. And today is the eve of trial for defendant Jose Ibarra. And he's in a last-minute hearing right now. Anything can happen here. He's set to pick his jury tomorrow. Let's go into the courtroom and watch.
I'll hear from you if there's something.
Yes, good morning, Your Honor. The state was contacted by the defense last week, and they let the state know that they wish to waive the defendant's right to a trial by jury, and instead this defendant wishes to seek a trial by judge only, a bench trial. When I was notified of that, the parties have executed a waiver and of his right to a trial by jury. And the state has agreed to a bench trial so long as the trial remains before Your Honor and those senior judges are brought in. And I believe we're going to commence the trial very shortly, so I don't think that will happen. So both the state and the defense have agreed to proceed with a bench trial in this matter. I have prepared a waiver. I believe they have executed the waiver, and we would like the court to inquire from the defendant, as you would in any time a defendant waives a constitutional right, to inquire from this defendant whether this is a knowing, freely, and voluntarily made waiver. I'd also like, if the court is so inclined to do, there is a part of the form at the bottom where the defense attorneys also have agreed that they have discussed this with their client and they agree with this waiver. And so to inquire from both the defendant and defense counsel about the voluntariness, the freeliness, for lack of a better term, and the knowing waiver of the right to a trial by jury.
Your Honor, I do have a waiver for you to consider. May I approach?
Yes.
He wants a bench trial. What? He wants a bench trial. So the judge scheduled tomorrow to be at the date where both sides will engage in the selection of the jury that will hear this case starting Monday. Now, this may change everything. This may mean they could start tomorrow because no jury needs to be picked now. He is waiving his right to a jury trial. Let's go back in together now.
Did you go over the waiver of jury trial and agreement to proceed with the bench trial?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you go over that with your attorney?
Yes, Your Honor.
Was it freely, knowingly, and intelligently signed and considered by you?
Yes, Your Honor.
Do you have any questions about your decision to waive a jury trial in this case?
No questions.
Have you had enough time to talk to your lawyers about that?
Yes, Your Honor.
And do you understand that if I grant this request, it cannot be revoked by you going forward?
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
Mr. Kirby, let me ask you on the record, have you had sufficient time to go over this waiver with your client?
I have, Judge.
And can you say collectively, you and the other defense counsel, are you all in agreement with your client's decision to make this election?
We are, Judge.
Is there anything else you think I need to know on this subject?
Not about this matter, Judge.
Ms. Ross, anything?
May I inquire? I know it may seem quite silly because the defendant is incarcerated, but stranger things have happened. Would the court please inquire to make sure that the defendant's age and the fact that he's not under the influence of any drugs and or alcohol at the time today or at the time that he made that decision? And I'd also like to inquire, I understand that Mr. Kirby does speak Spanish, and I know that they went over the form and have discussed this with their client, and just want to make sure that he either did it in Spanish or with an interpreter or both when he discussed this matter with his client.
Mr. Ibarra, are you under the influence of any sort of drugs or alcohol today?
No, Your Honor.
Were you under the influence of drugs or alcohol when you considered the waiver of the terms included in this form?
No, Your Honor.
Mr. Kirby, could you describe how did you translate with the assistance of Ms. Smith, or how did you discuss this with Mr. Ibarra?
Judge, what I can tell you is that the form was translated and we reviewed it with Ms. Smith, who is an interpreter for the court.
And then, were you present when that took place?
I was.
Is it your belief or understanding that she translated it to the client in an appropriate way? I mean,
I don't have any reason to think that that was not done, Judge.
Okay. And I ask you because I understand you speak Spanish.
I understand, Judge. Without getting into my fluency of Spanish, we brought Ms. Smith in for a reason. I am not qualified to tell you exactly what those words were. It was reviewed just like in any other case with a certified court reporter and court interpreter. And we have stated that Mr. Ibarra has stated that he understood it. We have stated that we've gone over it with him, and I'll leave it at that.
What else, Ms. Ross?
That's it, Your Honor. May the parties have an opportunity to discuss scheduling with the court, and that can actually be in chambers if it pleases the court.
Yes.
Thank you.
We can discuss that. I also recognize that Mr. Kirby has filed a follow-up motion for continuance on the true or real issue. Is that true?
That's correct, Judge. I think that it would be very similar to what we argued at the motion, but given the court's order on that, I have a feeling I know what the court is going to do. We just want to renew that motion.
Well, and I understand your obligation to do that. I can appreciate that. I think it's appropriate that if we probably need to address that now on the record. Have you had a chance to see that? I just saw it this morning.
I did see it, Your Honor. In the state's position on it, I think we have a little factual disagreement about the timing of matters. I'll repeat my position on the motion to continue, or at least putting all of the dates in context for the court in the terms of the true allele DNA results in this case. So the very first true allele report in this case was issued in April of 2024. That report was not disclosed to the defense until the very first round of discovery, which came out in May of 2024. So as of May of 2024, everybody is on alert that that some of the results, not all of the results, because some of the results are traditional DNA, some of the results are YSTR DNA, but there are also true allele results in this case. And so in May, everybody was aware that we have true allele results in this case. The true allele testing continued because this case is not yet 9 months old, so things were continuously tested. As things are tested and as reports became available, they were disclosed to the defense. The very last true allele report in this case was issued in September of 2024. It wasn't until the last results were issued in this case that the GBI could disclose and give to everyone, the state, meaning the prosecutors and the defense, the raw data that was produced as a result of the true allele testing in this case. And that raw data was timely subpoenaed by the defense. The prosecution in this case, in order to assist the defense, in order to get it quicker, also filed an open records request because we're permitted to do that in an open case. We worked together, defense and prosecution, as quickly as possible to make sure that they got the raw data as soon as they could. The raw data was produced to them in October, I think it was October 11th of 2024 is when they obtained the raw data from the true allele results in this case. And so I put all of the
Okay, so the defense team now requesting a continuance. So here are the big highlights. This is not going to be a jury trial. He doesn't want a trial by jury. Why? I have no idea. He has just chosen to waive his right to a jury trial, and proceed with a bench trial by judge, where the judge is the finder of fact, finder of law. That being said, the defense team is also requesting a continuance. They're taking issue with some of the true allele testing pertaining to the DNA evidence in this case. They want more time to do some independent testing of their own, as I understand it. And so perhaps the court will give them that time. You heard the response from the prosecution is testing continues, they turn it over. But if something has recently been turned over and the opposing side doesn't have an adequate opportunity to do their own independent testing, you could see where in the interest of fairness, the court may postpone the case. So let me bring in our law enforcement analyst guest today on the show, retired NYPD Deputy Inspector and the author of the book, Once a Cop, Corey Pegues. He's also a veteran, served in our Army. Corey, thank you for your service. I know I didn't get to see you on Veterans Day, but hopefully you will accept our thanks today just the same. So I want to ask you, please, about first the decision to go judge. Let's tackle that first, judge rather than jury. What did you think when you heard that?
Wow. Thank you for the Happy Veterans Day, and Happy Veterans Day to all the veterans, past and current. Wow. I would always go with trial by jury because you just need to put doubt in one person's mind. Going with trial by bench, the judge knows the law cold. There's really not too much wiggle room, and it's hard to put doubt. You got to have a really good defense attorney to put some doubt inside the judge's mind. So I'm pretty shocked that they went with the trial by bench, because usually when you're doing these cases here, I'm taking my chances with 12 to 23 people as opposed to one.
Right, Corey. So let's talk about the other issue here. There's still some true allele testing that needs to be done. Apparently the state got this evidence, and they said they're getting it on a rolling basis. You know, this case, it's not an old case. They said the first issued report came in 2024. There was one that came in September, and the defense needs some more time to have their own independent expert evaluate it. Do you think, in the interests of fairness and justice, the court may give that continuance to give some time, especially now knowing the way in which they're going to be proceeding here?
I think he's definitely going to give them that time. And as you can see, even with this hearing, it looks like the prosecution and the defense are working harmoniously together. So I can't see the judge not extending that time to them.